Welcome. We're starting our class. This class, for those of you that are taking it at Wake Tech, is criminal law, and we're going to focus. We have a general text on all criminal law across the United States, but there's going to be some supplemental material that's going to focus here on North Carolina. We're also going to move along with our text that's been adopted for the class, this is a freestanding course. It's perfectly reasonable to watch these videos, learn from these videos without the text. I'm not sure you could get a grade at Wake Tech here for it, but let's jump in and talk about the criminal law, some of the basics of it at first before we go into some of the more specifics. And this is going to be the purpose, the scope, and the different sources of the criminal law. One of the things that we'll be doing here is in this beginning chapter is dispelling some of the myths and the misconceptions that are around the criminal law. I think most of which arrives from popular culture. Okay, so we have learning objective slides. You're going to see these at the beginning of each of the chapters that we're going to cover. Excuse me. They're not necessarily directly related to work you're going to be doing in this course. They're more to give you a broad understanding of what's being covered in this chapter and what we're hoping to accomplish. So, for example, these follow a sort of pedagogy, giving specific goals like understand the four general recognized goals of the criminal justice system, know the meaning of police power, each one of these. Again, they're not particularly important for you to focus on as you listen to these lectures. They're really more kind of reflective and also included for the purposes of the college. So moving on here, let's take a look at some more. The criminal laws and the American system. You have to understand that the law is intertwined. The American criminal justice system is intertwined with the basic structure of our government, the democratic ideal of America. America is a society, like I suppose almost all societies are, is a society in tension. In tension between the desire to have order, to be safe, and the desire to have liberty, to be free. So the law provides us that balance. Now, obviously, some societies on the planet will strike a balance which is much greater towards the public order. These would be dictatorships. So there would be very limited democracy in these, in the political system, but also the law itself would tend to reflect that value. There's going to be some countries that have greater freedom than America. There are going to be maybe greater economic freedom, sometimes greater social freedoms. And again, that's kind of striking a balance where they're more interested in being free than they are interested in having an orderly society, as we view an orderly society. So how does this all come about? Well, you've got really, of course, the classic three branches of government. The legislative branch, which we'll talk about in detail, and the executive branch, judicial branch. But the legislative branch is the direct representative of the people, at least in a democracy like ours. It elects and enacts laws. Now, we're kind of used to, in America, focusing more on the executive branch. So if you hear a discussion of the government, particularly the federal government, you'll often hear people focusing on the president. The president wants this, the president wants that, the president is doing this at the border, the president is doing that for NASA or defense or whatever we're talking about. But what you have to understand, of course, is that for most of American history, the president had much less influence in the legislative branch. And the legislative branch was a much stronger part of the government. Now, whether that balance will redress itself and will emerge with a more, what's often called parliamentary system in the future, nobody knows. But the legislative branch as it's structured today is the one that actually enacts the laws. The executive may want a law. It may even try to create them in different mechanisms like executive orders, but the legislative branch is the one that has to sit down, particularly at the state level, and actually create the criminal law. Now, the executive branch is an enforcement branch. It says, okay, here's the law that's been created by the legislative branch. let me take that and enforce it. So if you had a law that said, we're having a contention right now about whether the January 6th events, insurrection, however you want to terminate it, renders the President of the United States ineligible to run for office, the ex-President of the United States, President Donald Trump. Well, you have a legislative branch that created a constitutional amendment to the United States Constitution. Now the executive branch, because this enforcement seems to be left to the states, the executive branch at the states is deciding whether it should enforce this part of the Constitution. Now, obviously, that's contentious. There are some people that say, well, you can't keep President or ex-President Trump off the ballot. There are some people, excuse me, there are some people that say you can. So that's got to be decided by some branch. Now, we don't want to leave it to the ones necessarily that created the law. We don't want to leave it to the ones that are enforcing the law. Instead, we want some neutral party to make some determinations. That's going to be the judicial branch. So that's how the system works. Each branch theoretically operating as a check upon the other. So again, arguably in American history, at least for the first couple hundred years out of the American Republic, the legislative branch was by far the most important branch. So what did it do? Well, it had the ability to actually pass legislation, to make law. Now, in the criminal side, because we're going to focus on criminal law here, most of this is done not at the federal level, although there certainly are federal laws, but at the state level. The state makes all these determinations, the different states, the 50-odd states of the United States, 46 if you want to be technical. There's 46 states and 4 commonwealths, like the Commonwealth of Virginia, the Commonwealth of Pennsylvania, the Commonwealth of Massachusetts, and I think the 4th one is Kentucky, if I'm not mistaken. But it doesn't make much difference. They enact criminal law. So, recently, in the United States, there has been a debate about abortion. It has been, because of the Supreme Court decision, left to the states to define the laws about abortion. And that means they're going to create criminal law about abortion. They're going to say, okay, these are the conditions under which if you get an abortion, seek an abortion, perform an abortion, you are committing a crime. Now, different states are going to arrive at, because the Supreme Court has left this up to the states, they said it's a state-level decision, they're going to arrive at different decisions as to what is the point of viability, what is the point at which a fetus becomes a human being, and at which the criminal law applies. What are the exceptions? What are the medical exceptions? All these are decided by the legislative branch, and they'll enact a law. The chief executive officer will participate in this. So, for example, here in North Carolina, if we go to the abortion debate, the governor of North Carolina is Roy Cooper currently. It is 2014. If you're hearing this after 2014, there'll have been another gubernatorial election, and there will be a different governor because he is term limited. But the legislature of North Carolina is dominated by Republicans. Roy Cooper is a Democrat. The Republicans would like a much more restrictive abortion law. The executive branch would not. So Governor Cooper has the authority to veto any laws they come up with. So he can't create a new law about abortion. But what he can do is he can stop the legislature, unless they can overturn his veto, from enacting new laws. Now, that means that both the state governors and at the federal level, the President of the United States can provide leadership. He can get his supporters to propose laws. He can support them. He can oppose them. He can give information about them. Teddy Roosevelt used to refer to the presidency, for example, as a bully pulpit, which is really a standing position at which you could make an argument that people had to listen to. So as the 20th century progressed, the President of the United States became much more powerful. And to some extent, this was reflected by the governors in North Carolina, for example. We went from a two-year governorship to a 4-year governorship. We gave them more veto power. Now, there was a reaction against that in North Carolina, so it waxed and waned a little bit where they took some power away from different executive branches. And there's currently a struggle from the North Carolina General Legislature to take some power away from the governor. But state governors can provide leadership. They're the most visible part of the government, which leads us obviously to the executive branch. Now, we shouldn't just think of the executive branch at the federal level as just the president, or at the state level as just the governor, because there's lots of people around him. He's one person. So in North Carolina, we have a whole bunch of people that they're called the Council of State, but there's a whole bunch of people that the governor appoints or directs or controls, and they can have a big example on the enforcing of the law. So, for example, in North Carolina, the governor appoints the head of the Highway Patrol, and he might be really interested. One of our ex-governors, Governor Hunt, was very interested in drunk driving. He really was at the forefront of leading a crusade in North Carolina against drunk driving. So he might order the head of the Highway Patrol to do a lot more DUI stops. So all these different agencies inside the executive branch of government administer and enforce the law. And sometimes there's a question about whether they can simply just ignore it, which is kind of a silent veto, if you will. Now, my favorite branch, because my training is in the law, of course, is the third branch, and that's the judicial branch. Again, we have side by side federal courts and state courts. But what it does is it operates as a balance. In theory, it's there to protect the public, so it's got that sort of crime control mentality. But it's also there to protect the rights of the people. So sometimes the government does something, and either in the creation of the law by the legislature or the enforcement of the law by the executive agency, it intrudes upon basic liberties, or liberties that are preserved either in the Constitution or in statute or in law. So it's up to the courts at that point to say, well, you can go no further than this. This law can't be put into effect. They can do this at the individual level by holding trials. And one of the ways they do that is they invite the public in, and this is where the public gets its say in this system. Yes, we elect our legislatures directly. They have a direct democratic voice. Yes, we elect the governors of the state, the President of the United States, indirectly, at least the President through the Electoral College. But here, we're individual participants. So a jury can be brought in, and the jury, unless the defendant decides to waive it, decides what the facts are in the case. Now, it doesn't decide the law, necessarily, but the jury does decide what facts happen. They also have another power called jury nullification, where they can look at a law and they can say, yeah, this law is just intruding on our liberties, and even though it's pretty clear that the legislature might want this or the governor wants this, we don't. And we're not going to convict someone who commits this act. And that can have positives, and it can have negatives. The state and appellate courts, of course, hear appeals from lower courts. Federal Circuit Court of Appeals hears appeals from federal prosecutions in North Carolina. Is the North Carolina Court of Appeals, and then ultimately the different Supreme Courts. The Supreme Court of the United States, of course, is the biggest of the big dog. It has limited review of state and federal convictions under what's called a certiorari jurisdiction. We're going to find rid of certiorari in a little bit. There's also a review via another mechanism called the writ of habeas corpus, where it's federal courts. And basically the way you get a writ of habeas corpus to get an appeal heard is you say, well, I really have almost no other way to appeal, and I still have habeas corpus. And again, this is something we're going to define in a little bit more detail. Okay, so federal courts, there are trial courts. The trial courts are called the federal district courts. Now in North Carolina, we also have two trial courts. We have our district courts and our superior courts handling our felonies. At the federal level, we take these districts and then we have an appellate or a circuit court that hears appeals from them. So they're called the U.S. Court of Appeals or U.S. Circuit Court of Appeals. And in North Carolina, we have the North Carolina Court of Appeals. So these are parallel agencies. And then, of course, you have the big dogs. You have the United States Supreme Court and the North Carolina Supreme Courts. Each district has, in the federal level, a corresponding appellate district. So you might be in District 5 or 6 or 8 or 9. So North Carolina is in a district with a few other states, Virginia, for example. But Texas would be in a district with someone. Montana would be in a district with a different state. And they're geographically based. Now, I decided to talk a little bit about the writs. And a writ simply is an order. A writ is, if a writ is granted, it is an order to a court to do something. So when I file, if I'm an attorney and I go in and I say I'm going to file a writ of certiorari, what I'm doing is I'm going to one of these appellate courts and I'm saying, I want you to really request the records of the lower court and hear my appeal. So it's a writ of certiorari is basically a request, if it at first, and then an order, if it's granted, to hear an appeal. So what will happen if you grant a writ of certiorari is the upper court, the appellate court, will write to the lower court and say, send us the records, we're going to hear this case. If it's denied at the criminal side, if we deny the writ of certiorari, basically we say, okay, we're not going to hear the appeal. The decision you made, trial court, we're going to uphold it. At least unless we go to the next writ that we could talk about. And this writ is called, historically, the Great Writ. And that is the writ of habeas corpus. And the Latin is literally to produce the body, or it's corpus meaning body, but produce the person that's been convicted. And what we have here is, and this exists both at the federal and the state level, is that you have someone who is confined, and he makes the argument that his conviction is unconstitutional or improper for some reason. And he has exhausted his other ways to appeal. He said, well, I appealed based upon a writ of certiorari that the evidence was admitted improperly. I'm going to file a writ of habeas corpus now saying this is just unjust. And it really requires that whoever is holding, whatever jurisdiction is holding, the person in prison or jail, or whatever restriction of liberty has been placed, that court has to explain the rationale as to why they're holding them. If a writ of habeas corpus is granted, it really means very often you're going to have a new trial or you're going to hear new information. All right, moving on from the structures of all this, let's talk a little bit about criminology and criminalistics. These are two terms that you'll sometimes hear in this class. Criminology is a relatively recent science, and it is based in two other fields, sociology and psychology. And what it looks at is it looks at something very fundamental. What causes crime? And how do we react to it? By making laws, in other words. So criminology is in some ways a theoretical field, which is not to say, as many Americans think, that, oh, well, it's just a theory, it's not terribly valuable. In fact, criminology, if properly applied, is the most important thing we would study about crime. Because it asks a question like, okay, why does crime occur? And if you can find an answer to that, if you can say, well, crime is occurring because of this, because there is discrimination, or crime is occurring because there is a dietary issue, there is a poison in the environment, or crime is occurring because of improper socialization. Well, guess what? You can seek to attack the root cause of crime, eliminate it, and you no longer have to worry about prosecuting people who commit crimes. Now you can avoid having the crime committed. Now, criminalistics is a little bit more practical. And criminalistics is pretty much looking at the science and the science testing and the evidence in criminal cases. So criminalistics is more practical. And in criminalistics, the crime has occurred. In criminology, although there's some study of crime after the fact, it's focusing on why. All right. The purposes of criminal law. Now, here are a lot of different purposes and a few questions about them. And one of the things I like to say when I'm giving a lecture is you have to understand that when someone says there are 3 reasons for something, or 4 reasons, or 6 reasons, there's probably 60. There's probably 600. At some point, though, you have to prioritize and say, this is the most important reason. You know, if I get into a fight with someone um, because he hit my car, okay, there could be lots and lots of reasons why I got in a fight. Maybe I'm a violent person. Maybe he, was aggressive himself. Maybe I had a difficult life, and I'm just an inherently violent individual who is unable to control their emotions. So there can be lots of reasons why the fight occurs, right? And then there can be very, very minor ones like, well, it's a Wednesday, and one of the reasons the fight occurred was because there's parking every other day and Wednesday on this side of the block, and I was on that side of the block. It can be really, really minor stuff. So when we talk about the purposes of criminal law, not to draw this out too much, there's going to be different people coming up with different purposes, and we're just looking at some. So one of the things is the purpose of criminal law is it's going to let us identify what we can't do and what we have to do. So and the first one's really easy for Americans to understand. Okay, it's illegal to jaywalk. It's illegal to murder. It's illegal to kidnap. Okay, I got that. But what do you mean by mandated? Well, these are things you have to do. And if you don't do them, it's a crime. For example, if you have been subpoenaed, or if you are talking to the police under order and you are not liable to incriminate yourself and they ask you a question, you got to answer. You have to cooperate. And if you don't, or if you lie about it, of course, now we got a crime. What this allows us to do, after we identify it, is those people who either commit a crime or fail to do what they're supposed to do can be punished. Now, this raises a really interesting question. Why are you punishing people? And this is something that many students don't think about. Okay, you have someone who broke the law. Great, now I want to punish them. Why? What are you trying to accomplish? Which leads to another question. Who should determine the punishment? Should it be up to an individual judge? Can he look at everything? Can he juggle everything? Say, well, in this circumstance, I've got there was recently a killing in Raleigh where I believe the person who did it was a 10-year-old child. Okay? So the question is, well, who should be punished here? Do you punish the parents? How much do you punish them? Do you punish the 10-year-old? One of the things you want to do is, don't you want to protect society from dangerous people? And this, by the way, goes back to criminology. Can you identify dangerous people? Do you know this person is likely to commit a crime in the future, therefore we have to treat him in a certain way? Or is he unlikely to? And then you can ask the question, what are the results if society doesn't feel protected? Can we reform and rehabilitate people? And what do statistics say about all this? Now, note, there's going to be a difference here between the criminal law and the civil law. The civil law, basically, if we're not talking about a contract, you have committed a tort. In some way, you have interfered with my rights. Maybe you chopped down a tree on my land. I can sue you about that. There's also the criminal law. If you come over and you steal my gas grill, okay, oh wow, all right, now the law will come and arrest you. But if you chop down a tree, I don't think the law is going to arrest you. It's going to really require you to sue me. Prove that it's your tree, prove that you were damaged because of it, prove that I owe you some money. All right, so let's talk now about the Constitution, because I've referred to this a couple times. This is a picture of it's a very stylized picture of the Constitutional Convention, I assume, because you got George Washington there standing like a superhero. You got all these other people pointing, and you got Ben Franklin sitting down there. He's the one dead center, and it looks to me, if I'm not mistaken with that, you got Alexander Hamilton leaning over talking to Ben. Now this could be a painting of the Declaration of Independence. It's hard to tell. Or it could be the Constitutional Convention, because Washington was president of the Constitutional Convention. He was most of the time absent at the Declaration of Independence because he was off leading the army off outside of Boston. All right, so in 1780s, the different states got together, 13 states got together, and they drafted a charter, the U.S. Constitution. And one of the things it said is okay, we're going to recognize that there are states and there's federal government, there's state law and federal law, and we're going to pretty much give the states power to make criminal law. And we're going to give a little bit of power to the federal government to make criminal law, but only where the Constitution pretty much directly says they have it. So at least at the beginning, for the first 150 odd years of the American Republic, most of the power for making criminal law, most of the criminal law is at the state level. Now this can be good and bad because sometimes the states can be very enlightened. They can lead to experiments to give people more liberty, to treat people more fairly. Sometimes the states can be very repressive. So very often you'll hear the term laboratories, that the states are laboratories where they test out ideas, and if they work, other states adopt them. That's a lot of what's going on here, but remembering that some of these experiments are pretty horrific, like the Jim Crow laws in the American South. Okay, so there are some specific constitutional limits on state and federal power. Now, at first, most of these were just on federal power. Most of the amendments to the Constitution were initially understood until they went through a process called federalization to only apply if the federal government did it. So the first one here, the First Amendment, protecting freedom of speech. The federal government initially couldn't make a law saying, well, you can't say that. Oh, you want to protest something, you can't say that in America. And if the federal government tried to arrest you, let's suppose you were opposing slavery. That's a good example. The federal government couldn't pass a law that said any dissemination of information in opposition to slavery, abolition, is a crime, because it would be really seen as a violation of the First Amendment, which protects freedom of speech. However, if you look at the records, quite a bit of this limitations of the First Amendment went on in different states at different times, because if you oppose slavery in, say, North Carolina in the 1840s or 50s, then North Carolina could shut you down. And you could say, well, what about my First Amendment rights? And the reply would be, well, they don't apply because it only applies if the federal government is trying to shut you down. Now, obviously, this changes. The Second Amendment of the Constitution of the United States, fairly famous in America, relatively unique in the world, is the right to bear arms. And again, the question would be, well, is this a federal right, a state right? Can the federal government restrict you? Can the state government restrict you? And, there have been a lot of debates about this. Then you've got the Eighth Amendment of the United States Constitution. It's prohibition against cruel and unusual punishment. Here we've moved from making a law to enforcing a law, which also blends us into the 14th. What is cruel and unusual? One of the debates we've seen in the 20th century is the death penalty cruel and unusual? The 14th Amendment of the Constitution, the Due Process Clause and Equal Protection, it really says that you have to follow a procedure in the application of the law which is fair and reasonable, due process. Moving on, one of the things that's prohibited is no ex post facto laws. All right, well, what's ex post facto? This is one of the first tastes of Latin we're going to get here, which is basically saying that you can't criminalize something after the fact and make it a crime and then punish you if I did this before you made it a crime. So what's a practical example of that? Let's suppose you made it a crime to sell cigarettes. All right, let's suppose that people decide cigarettes are poison, cigarettes are bad, we're going to make them illegal. So you make them illegal today. Let's suppose today is January 1st, 2025. Well, on January 2nd, 2025, you arrest somebody that says, well, back in December of 2024, you were selling cigarettes. that person could argue that, well, that was fine because it was legal back then. You can't, after the fact, make it a crime. Because this was a favorite trick or procedure to arrest people in other countries, where you would make a law and you would say, well, what you did then was legal, but it's not now, so we're going to prosecute you. So Article 1, Section 9 and 10 makes ex post facto laws unconstitutional. Another idea, and this is really not directly in the Constitution in that it's in black and white, it really goes back to a basic concept of English law. And American law is descended from English law. And there's another Latin term. Remember, we've had a few different Latin terms: writ of certiorari, writ of habeas corpus. This one is, and you don't have to worry about how this is pronounced, but the Latin maxim is nulla, which means no or non, pone sine lege, which is no punishment without law. And what does that mean? It means that unless you can point to me a statute that says this is a crime, then you can't arrest someone for it. So it basically stops the enforcement of a law that doesn't exist. It's a very basic principle. So one of the most important things that happened, this happens all the way back with the creation of Hammurabi's Code in the 3000 BC or 2 or 3000 BC, was the idea that it's very important that people know what the law is. It gets written down. Even if you can't read and write, you can ask someone if it's there. And if it's not there, then it's not a crime. And this prohibits people using the law as a sword. So sometimes people say the law should be a shield and not a sword. It should be able to protect people, not used to go after people who are otherwise innocent. Okay, so no punishment without a law for it. No one can be punished unless their conduct has been clearly made a crime. It doesn't let us do this retroactively, and it means that there has to be a clear legal definition of what the crime is, so that a reasonable person would know. One of the terms that you see now in America, you often hear the term reasonable man, but there's a great term in English law called, I'm going to paraphrase it, an idiot in a hurry. So would someone that's not too smart, that's in a rush, still realize that what they're about to do is a crime? All right, so there are different classifications of the law that we can talk about. Some of these are exclusive, some of them are not exclusive to one another. So one of the first divisions, excuse me, is we can break it up between substantive and procedural. Substantive criminal law is how we tend to initially think about criminal law. It tells us this is right, this is wrong. It's okay to jaywalk, it's not okay to jaywalk. You cross at the green, not in between, as they famously say. Or it's okay to go 45 miles an hour in a 45 zone, but it's not okay to go 55 miles. That's substantive. Then there's procedural law. How we can investigate things, how we can go forward with things, how we can prosecute things. So, for example, it's okay to question a suspect procedurally when they're in custody, but you got to read a Miranda. You can't torture people to elicit a confession, but you can lie to them. So a lot of those two terms, very broadly, most criminal law will fit in one of the two, but it also can fit in, well, is it a statute, is it a common law, or is it an administrative rule? And so these are not mutually exclusive categories. Statutory means basically it was passed by a legislature, either the Congress of the United States or here in North Carolina, the North Carolina General Legislature. Then you got the common law, which are these unwritten laws that have descended to us. And then you have administrative law, which is created by administrative agencies. And the bulk of law created today is not created by legislatures. It's not created by Congress or the North Carolina General Legislature. It's created by administrative agencies because the law has become so complex and there's such a need to deal with so many things that one sitting legislative body, whether it's the Congress of the United States or the legislature of North Carolina, doesn't have the time or the expertise to do it, so we let these agencies do it. An example would be if the IRS needed to set what is the standard deduction for 401ks, which is a type of retirement account. I was looking at this the other day. They set the standardized deduction this year, which is 2024, at $23,000. Okay. Congress didn't enact that. Congress didn't say, well, if you take more than $24,000 on your 401k and try to deduct it from your taxes, you can't. The IRS did, and that regulation has the effect of laws. If you did this with the attempt to avoid paying taxes, you've committed a crime. Congress didn't pass it, the IRS created that rule. Two more ways, now these two things are linked that we talk about it, and it's really three here, is you can break the law into felony or misdemeanor. Now sometimes you'll see felony, misdemeanor, and infraction. Now like I said, these are not exclusive categories, so you could have a statutory substantive felony, or you could have a common law procedural misdemeanor. But a felony is the more important cases. Typically a felony calls for incarceration for longer than 1 year, and a misdemeanor is a minor crime. That's going to call for, the usual penalty is incarceration for less than 1 year. All right, moving on. The government may regulate conduct by making conduct either criminal or civil. So if we look at this flow chart, first of all, the question is, can we regulate the conduct? Because certain conduct can't be regulated. Certain things the government has no business. Can they tell you how much you can breathe? No, right? But can they tell you how fast you can drive? Sure they can. Right? So some things we're going to call criminal, some things we're going to call civil. Now, sometimes those laws are a little bit murky. So, for example, I wouldn't put speeding, like this flowchart does, in the civil offense. Speeding is theoretically a criminal offense. But if you look at the criminal offenses, a lot of these are going to pop to mind as crimes: murder, rape, felony, theft, misdemeanor theft, so on. Civil offenses, these begin to look like something that are going to be punished by fines. I would say infraction is probably a better term here. But if we're going to make something and put it in the criminal offense in North Carolina, one of the things we're going to do is we're going to classify it as, if we look at the third part of that chart, either a felony or a misdemeanor. So what we do in North Carolina is we break felonies into different letters. We have the A felony, A1, B1, B2, C, D, E, F, G, H, I. So all the way down. And obviously the A felony in North Carolina is first degree murder. And if we go all the way to the bottom, the least serious felony would be something like assault. Then you've got your misdemeanors. Now in North Carolina, our misdemeanors are not broken into A, B, C. They're A1, 1, 2, 3. All right, let's talk a little bit about due process. Deprivation of life, liberty, or property. And again, this goes back to the Constitution of the United States. There's two parts of the Constitution, the 5th and the 14th Amendment, that have references to due process. Now, the thing about the Constitution of the United States that people have to understand is there's no little asterisk that says, for example, in the 8th Amendment, it says cruel and unusual punishment, that says, here's our definition of what cruel and unusual punishment is. You can't torture someone, but you can lock them up. You can't lock them up for 6 months in solitary confinement, but you can lock them up for 3. So when a general term is used in the Constitution or in the law, it calls for interpretation. So the due process requirements that we're going to see in the 5th and the 14th Amendment, okay, limits what the government can do to regulate conduct. There's certain things it can't do, and we're going to talk about a couple examples of this. We're going to talk about overbreadth and void for vagueness. One of the things we have to say is it can't be so vague that no one can figure out what the crime is. Like if it says, you can't be bad, that being bad is a crime. Well, bad is a very vague term. It's bad to not eat your vegetables if you're a little kid. It's bad to lie to your teacher, whether you ate the paste in kindergarten or something. But that's such a vague idea that no one, a man of ordinary intelligence, wouldn't know what the crime was. Somebody has to be able to look at it, either an idiot in a hurry, if we use the English term, or a reasonable man, someone of ordinary intelligence, needs to be able to look at the statute and say, this is a crime. The other thing is, the crime shouldn't be too broad. So you can't say it's against the law to publish photos. That's very, very broad. So we could narrow that down by saying it's against the law to publish photos of children having sex. Well, now you've got very specific conduct. You've got kiddie porn that I can prohibit. But if you say you can't publish photos, now you're interfering with my First Amendment rights, because the law is so broad it overlaps, or it is overbroad. So void for vagueness. You can't trap people into committing a crime unless a person could understand that it was a crime. You can't have arbitrary and discriminatory enforcements of the criminal law. And obviously something that is arbitrary or discriminatory makes it vague. So if you say, well, you can't, take a very vague term like cruel and unusual punishment is pretty vague. Right? One of the arguments is it's hard to tell what cruel and unusual is. And eventually what emerges is a consensus of what it is, but it's still kind of hard. Well, if I say it's a crime to support a terrorist organization, what does support mean? Obviously, if I give them money, I would say that's support that you could probably make a crime. So I think the better statute there would be, it is illegal to support a criminal organization by providing material means for their continuance. That lets a reasonable person see it. But if you have a terrorist organization, right now, while I'm recording this, where you have a war going on between Hamas, which is what the United States is recognizing as a terrorist organization, and the State of Israel, which many people across the planet, again, I'm not trying to take a side here, would say was acting improperly, was going too far. So you might have someone saying, well, I support Hamas's right to defend themselves. Well, you might have a statute that says you can't support a terrorist organization. If you say those things, aren't you supporting it? Well, because such a law would be too broad, it would be void for vague. And you don't want to have a chilling effect on the exercises of rights like freedom of speech that I just gave an example of, or freedom of travel. The overbreadth doctrine, and I love this next slide to some extent. You'll see there's a sign and it's blank. So suppose you're driving on a highway and you see this sign and it says prohibited and there's nothing underneath it. Well, what's prohibited? Is driving on the road at all prohibited? Is speeding prohibited? Crossing a double line? I don't know. So you can't have a law that's so broad that it captures everything. We really want it to be confined, compact. Okay, equal protection clauses. One of the issues about America is that for 250 years of our republic, we have struggled to define what equal means. And I think one of the positive things about America is that idea of equality has expanded. Not without problems, not without fits, not without retreating sometimes, but if you look at who was equal in front of the law, who should be treated arguably the best. At the beginning of the American Republic, it's a very confined definition, right? Certainly men, right? Women didn't have full rights. White men, white Protestant men, white Protestant men who owned property. Those were the people that had the greatest rights. But even there you would have discrimination. But as America goes on, in the 1860s, we fight the American Civil War. And in part, what arises out of the American Civil War is you no longer can, at least overtly now, not not practically. You can't overtly say, well, because you are a different race, right, I can treat you differently under the law. In fact, even when the grossest discriminations are going on in the United States, when you have the repressive Jim Crow laws, it has to be couched in a term from the Supreme Court. You can have separate but equal facilities, even though, of course, they're never equal. So we have the expansion of equality to different races, even if that application is haphazard and sometimes, frankly, ignored. Then we have the expansion in the early part of the 20th century to women, where we start to say, well, previously we haven't let them vote. We put restrictions on them owning property. Now I think we're going to, give them the right to vote. Now I think we're going to give them greater rights to, divorce and own property. So one of the things, the equal protection, if you look at it, is the Equal Protection Clause. The Fifth Amendment is written in the 1780s. The 14th Amendment is going to be written in the 1860s and 70s. And its applications are going to stretch all the way through here, the 21st century. So criminal laws must have an equal effect to all persons subject to those laws. Now, here's the debate. Are you going to include citizens here? Is it just citizens of the United States, or is it anybody that's in the United States that gets equal protection? That's kind of one we're fighting about right now. Do we expand the category of equal protection to include undocumented immigrants? States can make classifications for the purposes of applicable criminal law, but only if they're reasonable. And sometimes they go too far. Classifications based on race are inherently suspect and subject to strict scrutiny. So, now it's not a criminal law, but one of the things that happened in North Carolina was we redrew our congressional maps less than a decade ago. And one of the things that came out was the general legislature redrew those maps specifically targeting racial groups. In fact, if you read the court decision, it was laser-like precision, as I recall. And the Supreme Court of the United States looked at a violation of the law saying, well, you are discriminating based on race, and anytime that comes in, we're going to look at it with strict scrutiny, and we're going to strike down your maps. You can't create legislative districts just to preserve white majority. Any classification based on race are inherently suspect and subject to strict scrutiny. So if you pass a law that said anybody that looks brown can be stopped in North Carolina and we can request their ID because they might be illegal immigrants. The illegal immigrants are coming from, pick your country, Mexico. Although net immigration from Mexico is actually zero, or effectively zero. Most immigration is now coming from Central and further South America. So it's a little bit different. People tend to use the term Mexican pejoratively and too easily. If you pass that law, we would say, well, no, you can't do it. That is a procedural law. You can stop somebody, but it violates equal protection. Well, where does the criminal law come from? Let's talk about some of these sources. I had referred a little bit to common law. More than 1,000 years ago, right around the reign of someone called Henry II of England, about 1000 AD. Those are rough numbers. He started to create the English legal system. Now, of course, in 1000 AD, most people could not read or write. So a lot of the law is going to be focused really upon decisions made in courts and customary decisions. And this, at least in part, and I don't want to get into a deep history of the common law, it created a body of law which was unwritten. Now, most of this law over the next 1,000 years has been reduced to statute. So yeah, at one point I assume things like burglary or arson were common law crimes. But gradually over time, the different state legislatures like North Carolina or the federal government, or the English government in fact, took these laws and said, well, we're going to define them more specifically. We're not going to leave them vague and unwritten. So there is still some common law out there. There's a handful of crimes I could talk about in North Carolina. One of the ones is called going armed to the terror of the people, that are unwritten, not passed by a legislature, but are still a crime. But most fall in the second category. Most of the criminal law we study are laws that were passed by the North Carolina State Legislature, or if we're looking federally, the Congress of the United States. Virtually all the laws out there, now North Carolina criminal law is found in Chapter 14 of the North Carolina General Statutes. So almost all of this was found and was created over the last 200 odd years of the existence of the state of North Carolina by the legislature. They have written them all down. So now if I want to look at what burglary is, I don't have to look up case law to figure out what the common law says it is. I can go to the North Carolina General Statutes, because there is a statute. I also, although there's not a lot of this we're going to talk about, there is also administrative law. Different administrative agencies can make law. So you might have an administrative agency that says, this is the level of lead that you can put into the environment legally. Right? Because let's suppose you're running a smelter. You're taking ore that's being, you're making car batteries. I don't know, you're making something, steel. And one of the byproducts is lead. Well, you got to do something with it, and what we allow people to do is we allow to put it back in the environment. Either you put it in, like if you're talking about a hog lagoon in eastern North Carolina, you put it in a hog lagoon, a retention pond, cesspool if you prefer, and it gets released in the environment. Well, how much can you release? The legislature is not going to pass that number. An administrative agency is. And if you violate that, it can be a crime. It tends to be more technical. It tends to be things we don't focus on. At least in this class, we won't talk a lot about administrative law. All right, just a few more slides to go here. Foundations of American law. Most of our common law can be traced first to England. And gradually what happened is we began to realize that a lot of the law needed to be defined. And by the 1600s, there's this struggle that you see in England between the king and the parliament, between the legislature and the executive branch. And this struggle really is reflected in the foundation of American law, because right around this time this struggle is taking place, the settlement of America is taking place. So if America had been settled 200 years earlier, we'd have a different legal system. But America was settled really at the height of this struggle between the executive branch, the king, and the legislative branch, the parliament. So if we look at kind of a timeline of this, let's go to the next slide. These are important historical events. Way back we have Magna Carta. Now that's been a bit exaggerated how important that is, but basically what it says is there are certain fundamental rights that exist that the king can't interfere. See the beginning of that struggle? 1820, we have the settlements in America. We have the Mayflower Compact. The Mayflower was the ship that brought the pilgrims over to settle in Massachusetts before they disembarked. They got together and kind of created a little constitution called the Compact. At the same time, we have a struggle in England between the Parliament and the king. This actually results in a civil war. The king is executed. They have a temporary republic called the Commonwealth. The king is restored, but during this restoration, the English Bill of Rights is granted. Now that should sound pretty familiar because less than 100 years later, we have the Declaration of Independence in America. We have that same struggle. We have a struggle between the King of England and the different state legislatures of the different colonies, the 13 colonies. Now, of course, there was more than 13 colonies. There was actually 26 colonies. But those colonies will declare independence and there'll be a struggle. Within 10 years, we decide, yeah, we still need an executive. We decide not to have a king. We decide to have a president. And we create a constitution which enshrines the beginning of these rights. It goes back to Magna Carta. And this culminates in 1791 with the adoption of the Bill of Rights, a lot of what we're talking about. So here is where we stake out and say you can go this far and no further. To both, by the way, the legislature, different state legislatures, but we're focusing on the federal government in 1791, and the president. So these are important historical documents that are related to American criminal law: U.S. Constitution, English Bill of Rights, Magna Carta, Mayflower Compact, Declaration of Independence, U.S. Bill of Rights 1791, arguably the most important there. All right, these last couple slides, not really something I spent a lot of time talking about. They're included in your text, and I'm sorry for those of you that are watching them without the text, but they're really thinking points. One of them is there's a link to a 60-minute, which is a TV show here, news TV show, and it's really discussion about assisted suicide. So assisted suicide has existed in history forever. In some societies, assisted suicide, not a crime. In fact, it was perfectly okay. Suicide was accepted. Now, suicide has in Christianity, has an assumption that it is an unforgivable sin to commit suicide. So in English law, suicide was criminalized, and assisting suicide was criminalized. Now, the term that has come into the English language is euthanasia. So in this video, it was really a discussion about, can we say that helping someone end their lives is a crime? Or is it a private decision? Should it be a crime or not? And does it go back to, well, is there some fundamental right here? You know, if you say, well, yeah, suicide's a sin, therefore we can make it illegal. Wait a minute, aren't you enforcing your religious beliefs on me? And, you know, you have to at least pause to think about that. And that kind of goes to the next slide here, which is there's another one about there are criminal laws, there are civil laws, administrative laws. And you can consider how they relate to different cases. And this is beyond this is beyond the 60 minutes euthanasia issue. This is more about what are the different types of laws here, you know. And in fact, one of the things that can happen is there might be something that's not a crime, but that it's easy to sue someone about, so you can stop that behavior civilly or administratively. You can make it almost impossible to do it. All right, well, we finished the first chapter here. I've tried to keep it in right about an hour. There won't be a lot of these thinking points going forward, but we have a number of chapters to look at. I'm going to post each one of these as we go through the semester. Some of you will be watching this after the semester is over, so I apologize if I'm talking about 2024 and it's 2025 or 2026, although usually I don't keep these up for more than a couple of years because they update the text. So basically I will keep most of these chapters at right about an hour in their lecture, because I don't have, if I'm teaching in class, I have a lot more give and take with the students. So, someone might say, well, explain to me the common law again. I don't understand what's going on. I can't do that here because I don't have that interaction. So this is just a broad overview of this chapter, and I hope it helped you understand it. And if you're in my class, feel free to email me at Wake Tech. I'll be happy to answer any questions that arise out of this. I know most of you that take my classes take them online. A number of professors don't provide copies of lectures, but I do, because I think it's somewhat helpful as opposed to just learning by themselves. All right, well, other than that, I hope you enjoyed it, and I hope when you're ready and when it's prepared, because I'll be working on it probably this week or early next week. Usually when I speak for an hour straight like this, my voice gets a little bit raspy, particularly if I teach most days. It will be available as soon as possible. Certainly within the next week or so, we'll go on to Chapter 2. Like I said, if you're taking this class later, you don't have to worry about that. because they'll all probably be up by this point. Have a happy and productive day, and I hope you enjoyed the lectures.